So getting into what we're going to talk about today, obviously it's Privacy Week 2020, and yes, we were meant to have Privacy Week in May, but I think the need to defer it due to COVID-19 has actually been to our benefit in a way, because we've been able to align it quite well to Privacy Act 2020 and really get engagement and attention at this stage just before 1 December. So we basically thought that this was a good way to kill time while we wait for Wisconsin and Michigan votes to be recounted. What else are we going to do? But speaking of which, we've also got a privacy poll on the Slido. So get in there and tell us where you think your agency is rated in terms of readiness for Privacy Act 2020, and we can have a look at the results of that poll at the end as well. So as for today, look, we've heard a lot from John and from other people over the last, well, I would say sort of 5, 10 years almost, because we've kind of known what's coming, but really specifically in the last 1 or 2 years about what's in the Privacy Act and what's not in the Privacy Act. So that's not what we're going to focus on today. What we really want to talk about today is, what does this mean for us? What does 2021 look like for agencies? What does it look like for the OPC? And what's the regulatory model that they're going to have to put in place to meet the new approaches that are facilitated by the Act? I'm particularly interested, John has proven himself in his first term to be a very pragmatic, a very helpful, and a very fair commissioner who's really sought to make privacy easy. In fact, it was one of the earliest mantras, make privacy easy. And so it'd be interesting to see how that rolls through into the new Act, where he does have more compliance powers, more enforcement powers, and how that will balance with that idea of being that fair and pragmatic commissioner. So it'd be really great to hear some thoughts about that. So we'll move into questions shortly, but I think first, John, we were going to show the ad.
Sure.
Yeah.
Great.
Personal information is precious. You have to treat it with care. If you're someone who uses personal information, you must protect it and respect it. Make sure it's hidden away from others, but easy for you to find. The Privacy Act has changed. You'll have to report serious breaches. Know what's new at privacy.org.nz.
Awesome.
Cool. Thanks, Glenn. I just wanted to briefly comment about our TV commercial. It's the first one we've ever had, and it's the first sort of big public awareness campaign that we've had. Broadcast TV being what it is, probably more people in this room saw the ad than when it was first aired on Sunday night on TV1 and TV3. But we're really pleased with it, and I wanted just to mention the creative concept behind it, which is that each of the actors has dual roles, right? In one scene, the young woman is handing over her personal information to the mechanic to pick up a courtesy car. In another, she is the nurse who is the custodian of personal information and is giving it over to one of her patients. The guy who's sweeping up at the rugby club rooms is the one picking up the patient notes. And so it just really nicely illustrates, I think, the way that we all have multiple roles. We are the subjects and we have rights under this law. We also owe responsibilities as agencies. And I think the producers and the creative team have done a really fabulous job. So, grab the URL and flick it out to your networks.
Thanks, John. Did you want to say anything about the slogan, privacy is precious? I like that. I was just wondering if there was any kind of story about where that came from.
No.
Obviously, I should have warned you about that particular question, but I didn't. So that's a good start, isn't it? No, it's a great slogan, though, and a great campaign, and I think a lot of people appreciate the fact that this has been one of the craziest years that they've had to contend with, not only due to privacy, so getting that material out, the resources out has been...
Well, the creative team that brought us this and came up with Privacy is Precious first presented a number of different privacy, what they call territories, and the preciousness was the second one they came up with. The first one was this concept of safe hands, and the art that they presented in the pitch showed data falling into these hands. And all I could think of was, I've been told to wash my hands for the last 6 months, and everyone who sees this ad is just going to think it's another angle on COVID. So we sent them back to the drawing board, and we're really pleased with the ultimate result.
Great. All right. Well, yeah, it's come out as a great campaign, so I think it's going to help a lot of agencies, certainly during Privacy Week. All right, so getting into some of the substance then, I don't want to linger too long on the Privacy Act 2020 itself, but it would be great as a bit of a recap, I suppose, to hear from you about what you think the key changes are to you. You know, what means the most to you in that new law?
Well, there's, you know, it's a fairly modest refresh of the Privacy Act, isn't it? In terms of new policy, not much is going to touch you or industry particularly. The significant one is mandatory breach notification, and that's one we should probably spend a little bit of time talking about. There will be an obligation to notify affected individuals and my office of a privacy breach which has caused or could cause serious harm. And this is the thing that we've probably spent the most time preparing for, and the bit that I'm most worried about. I'm a bit worried because mandatory plus uncertainty equals erring on the side of reporting, right? And this was a theme in submissions to Select Committee, and I'm concerned really that an agency that experiences a near miss or something's gone wrong, they come to a privacy professional, to a lawyer, and they say, well, I'm not sure whether it's caused serious harm or could cause serious harm. Let's err on the side of reporting. That's the easiest default. I am worried that that could cause over-reporting.
Yep.
Now, one consequence of that is that my office gets flooded and the important messages get drowned out. I'm actually not worried about that. We'll work with that. We'll filter that. But do think about the individuals, because if you're forming a conclusion that you have reached that serious harm threshold, you are under an obligation to notify the individuals. It's not just about telling me. So what's the impact of these weekly notifications that something might have gone wrong? It undermines confidence in your organisation. And I tell you, there are people out there that take this stuff really seriously, and it can really be anxiety-provoking for quite a significant proportion of the population. And let's all recognise that the anxiety tide this year has really risen. And so just be mindful of the impact of taking the easy way rather than making a thoughtful and sober assessment of the likelihood of some harm, using the criteria that the Select Committee dropped into the ad, which I'll let you go through because I'm sure you've got it off pat.
The criteria,
yeah,
of course.
Come on then.
Okay, so it's the sensitivity of the data, the nature of the recipient, the level of security safeguards. Anyone else want to yell one out? Mitigations against harm.
Other relevant matters?
Yeah, well, it's not much good.
Yeah, so the serious message is, this is a really important obligation. Why is it there? It's not just to populate the Notify Us tool that we've built to help agencies. It's there because you've failed in your responsibility to securely hold people's personal information. So we owe them a responsibility to restore their agency, to let them step in and take control for the lapse that you've caused, right? So let's always keep that individual at the centre. Are we going to do them more harm by notifying what we think is a near miss and thereby keeping ourselves clear of possible prosecution? Think about that.
How much has your office seen in the run-up to this new law a change in behaviour under voluntary breach notification guidelines today? Is there an upswing as people start getting used to this new world, or do you think there will just be a switchover?
Yeah, it's really hard to notice any trend. Most of the voluntary notifications we get, I think, come from the public sector. So having this obligation communicated into industry is probably going to see a significant upswing. We've seen in Australia, when they moved from the voluntary to the mandatory system, they noticed about a 7-fold increase. We're tracking at about 250 notifications a year under the voluntary system at the moment, which has been trending upwards over the last few years. So if we follow the Australians, we'll be looking at somewhere between 1,500 to 2,000 a year pretty soon, I think.
And that might be a good segue, I think, into the way that you will enforce these new obligations, and particularly the more strict obligations. the likes of cross-border information sharing prohibitions, the likes of data breach notification. I mean, yes, we've seen the law for a number of years in some form, and we had some idea what was going to be in there, but we haven't had a long lead-in time from the time when it was confirmed what that law would look like. How will that kind of inform your enforcement approach early next year?
Well, we've developed a compliance and regulatory action framework, which we call our CARAFT, which will inform that. And it's, you know, to anyone who's looked at regulatory policy, you'll see nothing sort of radical or new. It's that regulatory triangle, right, with the thick end at the bottom being promoting voluntary compliance through education and the sort of soft regulatory approach as we work our way up through the regulatory tools to the pointy end. We now have at the, you know, the pointiest we can be is compliance notices or prosecutions.
It's a little bit pointier than it is today.
Yeah. So we actually do have some tools. In terms of the new obligations, the new Principle 12 with export of data offshore and breach notification, I think we'll be, at least for the first 6 months or possibly even a year, right down to that base level. We'll be trying to get alongside, encourage people to do the right thing, work with them when they are struggling, or if they're acting in ignorance, help relieve them of that ignorance, and really sort of focus on getting that education and awareness and compliance.
Yeah.
For stuff that people should have been doing for 27 years, I'm going straight to the compliance notices.
Yeah.
And they'll be
okay.
fluttering like autumn leaves.
That's exciting. Okay, it's good we've got this on record. This is good stuff. I like that euphemism as well. So that's really clear that there is going to be some wriggle room around those, or not wriggle room, but some, I guess, understanding around those really new obligations that agencies suddenly have to grapple with, versus the stuff that hasn't actually changed. And then you've just got new tools to do more about those kind of sort of recalcitrant agencies or those systemic breaches. And I think that's very helpful for agencies to understand what they're in for. And I guess on that educative approach you've talked about, it might be a good time now to have a quick chat about the model clauses that you've just done in terms of that cross-border. Obviously, it's only one way to share data cross borders, but I suspect it's going to be a very popular one because it gives some control to the agency and a little bit of confidence, I suppose, that the person that they're disclosing to is clearly subject to some sort of obligation. Do you want to have a chat about what you've done there with those model clauses?
Sure. It's, you know, as I've travelled around promoting the Privacy Act and talking to groups, the new Principle 12 has been the issue which has provoked the greatest interest and which industry is most concerned about, I think. So the most common question we get is, you know, is this going to affect my ability to use cloud storage? And the answer that we're giving is no, it isn't. The principle from the 93 Act was intended to be carried over. There's a little bit of dispute in some legal academic circles as to whether the drafting has replicated the processor-controller distinction that was in the 93 Act, expressed there as agent principle. But we believe the policy intention was that should have been maintained. And so what that means is, if you disclose information to an agency for the sole purpose of processing on your behalf, and that other entity doesn't use it for any of their own purposes, it's deemed at all times to be in your control. So the new Act talks about where agency A gives B information, it's always deemed to be under A's control. So it's not even a disclosure. So my office infrastructure is all hosted on Microsoft Azure in Sydney. And you know, that is not subject to Information Privacy Principle 12. The other issue that might be overlooked is the effect on Principle 12 of the explicit extraterritoriality of the Privacy Act. So with that, that means that agencies that are doing business in New Zealand that may have no physical or legal presence here are still subject to the New Zealand Privacy Act. So again, if you're disclosing to an agency that is already independently subject to the New Zealand Privacy Act, you don't need to engage the Principle 12 protections. Yeah. And what we mean by the Principle 12 protections is that the new principle says you shouldn't disclose to an agency that's outside New Zealand unless you've taken some due diligence to assure yourself that there's a comparable level of privacy protection. Now that's quite onerous, to figure out, well, what is the legal protection regime in South Korea or New Guinea. So one of the alternatives to doing that due diligence is attaching protections to travel with the information. It's an approach in Europe which is called model standard contractual clauses. So we've commissioned Chapman Tripp to produce model contractual clauses. They're available for you to use on our website. So that basically means that the recipient agency, the B in that scenario, agrees to be bound by these clauses, which essentially replicate the obligations that an agency would be under in respect of that information in New Zealand. So it's a private contractual extension of the jurisdiction into that other jurisdiction. So I'm hoping that that will reduce the kind of transaction cost of this new regulation.
So just on those then, we've got a question here that's raised a really good issue, and it's getting those model clauses to work in practice. Now, any privacy nerds in the room will know about Schrems 2 and the kind of the takeaways from that case in Europe, which was around the Privacy Shield particularly. But it had an impact on things like standard contractual clauses and the idea that someone in this question on Slido has asked whether they're just a checklist, how meaningful are they really? And Schrems 2, one of the outcomes was that agencies couldn't just rely on a contract, they needed to look behind the contract and make sure that the agency signing it was able to meet the contractual obligations that they were signing up to. They could meaningfully protect the information that they, I don't want to say audit, but some level of assurance. How would you see that working in practice?
Well, I think we're a long way from Schrems and we're a long way from the European Court in the way that we administer our privacy regulation here.
Sure, yeah.
I think that would be quite onerous to require a business to do due diligence on an agency in another jurisdiction. So I'm not sure. Unless there's sort of willful blindness or negligence, I don't think we'd be expecting that level of kind of audit or due diligence.
Okay, that's great. And I guess the other thing is, I know we're a long way from Europe, but a lot of people, we're seeing increasingly agencies here having to grapple with GDPR as they work out of New Zealand and look to market into Europe. And so we have already had a lot of confusion around the idea of this data processor and data controller issue, particularly data protection addendum or addenda that you would put onto a processor contract versus model contractual clauses or standard contractual clauses that would relate to overseas jurisdictions. And I wanted to just note and get your thoughts on the fact that Principle 5 has always required us in New Zealand to take some of those contractual steps to protect data when a service provider is using it, and that would just continue, right?
Yeah, well, I mean, that's always been my view, that back when the Law Commission was deliberating about the regulatory framework, that an obligation on an in-country agency that requires them to take reasonable steps to ensure the information is secure is enough. That actually says to them, you can't send this personal information off to somewhere without any cares as to what's going to happen to it in that destination agency. So, I'm not sure that I agree with the need to have the new Principle 12, but Parliament's put it in there, and we have to administer it.
Okay, yeah, great. Just quickly, you've always had an ability to sort of prohibit on a case-by-case basis a cross-border transfer. You've had that power in the Act, and it's carrying through to the new Act. How do you see these two, Principle 12 and that ability to say no?
Well, we haven't always had it. That was enacted, I think, in 2011.
Sure, sorry, yeah.
And that was, as I recall, a result of the negotiations with the European Commission. So as one step to satisfy the Europeans that we had an adequate level of privacy protection. They were concerned about transmission to third parties and said, what are you going to do to stop it? So again, it's, I think, a redundant and failed policy. It's never been used. I don't know how the Privacy Commissioner would be seized of information showing that data is coming in to an agency and out to another one. How would we know? So I do think that some of the some of the questions we've seen from Europe during the adequacy review, you know, they're pretty kind of technical and theoretical in their application, and not necessarily very practical or grounded in reality.
Which is, probably an approach we see quite a bit out of Europe. So we try not to read those things from the European Commission or other people. We prefer your stuff.
Oops, I forgot this has been live streamed.
Okay, so coming back to the carafe.
Speaking of which, live streamers can use the Slido as well.
Oh, yes, they can. You can use Slido.
Is there a Slido code?
Yeah, Privacy Week 2020. Yeah. So coming back to carafe, which is just to remind you all, is the Compliance and Regulatory Action Framework. It's great, by the way. So I've had a sneak peek of it, just so that I could actually talk to you about it today, and it's excellent. I really like it. It's very clear, and it's going to help agencies understand what way you're working. But there are a couple of bits of it that I wanted to talk to you about particularly. One of them is, and this is obviously off the back of a change to the Privacy Act around cultural perspectives on privacy in the matters that the Privacy Commissioner has to take into consideration. And so you've developed a new guiding principle, which you've described as Ko Tui Tui, which I think means something around interweaving of cultural aspects. And it's around Maori partnership, and it's wonderful, a really lovely guiding principle. And I would love to hear more from you about how you see that playing out in practice. And I appreciate that it's a kind of a new thing to think about for the office.
Yeah, well, I think I'm grateful to have the prompt of the Privacy Act 2020 to the statutory requirement to take into account different cultural approaches, because it is an area I think that the office hasn't done well. And as a statutory entity in an organisation founded upon the Treaty of Waitangi, we have obligations to engage with Māori and to learn from Māori and to bring some of that understanding of Te Ao Māori into the way we interpret the Act. And there are many similarities. You know, I've been talking to people about the concept of personal information as tapu in some circumstances and noa in others. You know, we see it's a treaty right that Māori have to protect their taonga. And, you know, personal information is easily conceived as taonga.
Yeah.
You know, privacy is precious. Personal information is precious. And, you know, one of the harms that people are able to assert in Section 66 is expressed in very ethnocentric terms. Oh, sorry, I'm still in 1993 sections. I'll have to switch over on the 1st of December. But, you know, one of the factors that we can take into account is a significant injury to dignity, significant loss of dignity. Well, again, you know, why don't we equally regard a loss of mana as a legitimate basis for asserting a harm resulting from privacy?
Yeah.
So we've got a lot to learn, and one of the challenges I think in incorporating Te Ao Māori into our way of working is understanding a whanangatanga approach, right? So the different unit of protection in some contexts, that a whānau-based approach is much more important than an individual-based approach, which is quite a fundamental challenge to the way privacy is treated in the Western rights-based, human rights-based tradition. But I think it's a challenge that we really have to confront.
Yeah, and I suppose it's a challenge. Only yesterday I was talking to someone who works in Papua New Guinea and is collecting information about tribes there, bringing it back, and he tries to make sure that it's anonymized, but in fact he realized that might not be enough because they have similar concepts around a kind of cultural group sense of privacy, and that information, whether it's identifiable or not, is part of their inner being, it's part of their tapu.
Yeah, and there's a rising conversation about Maori data sovereignty, and I'm keen to be informed by that discussion. You know, Statistics New Zealand has a Maori Governance Advisory Board, which I hope to get some of the benefit from. Yeah,
okay. Oh, that's excellent. The other thing I wanted to quickly check on, and we've talked about this before, the Compliance and Regulatory Action Framework, I need to keep checking what that stands for, anticipates a more strategic approach from your office to the way that you use your enforcement powers, which makes sense. You've got a lot to cover and a lot more powers at your disposal. Now, obviously, we're used in New Zealand to a very strict complaints-based kind of, not strict, but a strongly complaints-based privacy jurisprudence, if you like. And so you're going to have the opportunity, I suppose, to guide the way you use your powers to get the best outcome. How do you see that interacting with the sort of your obligation to manage complaints on an individual basis? How will that work for individuals and their sense of their expectations, I suppose, of the office?
Well, you know, I have, as you know, a team of really dedicated professionals, and they have values of equity and equal access to justice and fair treatment, and that's really important. But all complaints are not equal. There are complaints that, and complaints, you know, just to go back to the beginning part of your question, sort of influencing conduct across the whole economy by means of complaints is a very, very inefficient and ineffective way, I think, of regulating. One person makes a complaint against one agency, and I have a highly qualified, dedicated person spend an average of, cost an average of about $1,300 to effect that change. And the impact across society is very limited.
Yeah.
So one of the things that I want to do is give my staff more autonomy to make decisions about the level of input, based partly on the regulatory, the diagram in the carafe about seriousness, impact, and obviously a matter which has significantly affected an individual deserves a full, the full resources of the complaints service. But a matter which may have had less impact on an individual but has wider implications across the economy, perhaps also deserves the application of extra resource. And a lot of things, we might just say, okay, we've had a look, go to the tribunal. Spend your own money, access your justice. We're a gatekeeper. That doesn't mean to say we have to apply, 100% to every complaint that walks through the door.
Yep, sure.
Our meagre appropriation has almost been entirely soaked up through this demand-driven workflow, which we have been powerless to control, and every commissioner has tried to influence it. So what we've been able to do with a successful budget bid in 2020 is recognise areas of unmet need that we're not achieving, draw a line across the resources allocated to our existing demand-driven work, get some more money from budget, and dedicate that entirely to our new proactive, more strategic focus. So freeing up that resource. So I hope to release more resource from the investigations and dispute resolution just by doing things differently and empowering staff to take more autonomy and responsibility for that, how that resource is allocated, and to apply more resource to scanning the horizon and looking at areas that we think are going to have the greatest impact for the greatest number of New Zealanders, rather than just the squeaky wheels.
So that's a good segue to talk about the internal resetting at the office and that the line you've drawn and the new parts of the new functions of the office to meet this new way of working. Can you tell us a bit about that, what new staff you've brought in and how that model might look? Sure.
So we haven't brought in all the staff yet, but we have got an organisational chart which has the positions on it, and I've hired an assistant commissioner, strategy and insight. So that's that second tier level with not many staff at this stage. She'll have an analyst, maybe a couple, but it's uncrowded. When we had a conversation in the office about the new structure, there were submissions that, well, actually the policy team should be over there. And I said, no, actually no, because policy, the way we run it at the moment, is demand-driven as well. It's all these inputs from government, COVID, is going to soak up that resource. So this is an uncrowded resource whose responsibility is to look at what's coming into the office and think about it strategically, to scan the horizon domestically and internationally and say, well, what do we need to position ourselves for? Where can we be of greatest influence? So she will have a principal Maori advisor, allowing us to build those connections we discussed earlier. Yeah. And we've strengthened our public affairs and communications team. I've also got a compliance manager, so he will be responsible for looking at how we deploy the sort of more pointy end of the regulatory triangle. And he'll have a team working for him as well. So that will mean there'll be three managers. There'll be a compliance manager, an investigations and dispute resolution, and a policy manager. And they will convene as a panel, together with General Counsel and Public Affairs, to look at the inputs that could be addressed in each one of those teams, and find which would be best placed to handle it. You know, so not just every thing that comes in as a nail to be met with the complaints hammer.
Got it.
So that's our approach.
Okay, yeah, that's pretty exciting. And just on that, I've forgotten the title of the new Assistant Commissioner's strategy and insights. So yeah, the word insights piqued my interest. Obviously, you know, for companies and government agencies who are complying with the Privacy Act, a big part of the new world is intelligence and insights and data and using it for these broader purposes. Do you see your office doing a similar thing?
Yes.
Will you be using that data?
Yes, we will.
Okay.
Yeah. I mean, you know, you might think, okay, so John's going to throw all his efforts at facial recognition or something, you know, something bright and sparkly. Actually, when we look at our, you know, I see there's people still standing or leaning at the back. There are actually plenty of seats down here if you want to come down. But you know, you don't need to do sophisticated data analysis on our casebook, which is 800 or 900 complaints a year, to see that a huge resource that we are expending, it goes to about half of those, 400 or 500 a year, is simply people asserting their right to have access to their information.
Yeah.
And there have got to be ways of improving the way agencies are discharging their responsibilities there. And so, you know, we'll apply some resource there. If we can improve that, then we release some of that complaint investigation resource to deploy to other matters which are important to individuals or of greater significance in the wider economy.
Okay. And just on that kind of those strategic thoughts, the planning ahead, do you have, well, someone described it in a question here, which I liked, as a hit list, but, you know, we don't need to call it a hit list because we're trying
you
to...
could put an S on the front.
Yeah, you could, but I can't say that because this is a live stream. But, you know, looking at your, obviously, you've got those layers of the pyramid, and your hit list might be different depending on your education focus, your compliance focus. Are there any particular industries or sectors that you feel will be a target, or at least more heavily watched under the new law from a compliance perspective?
Well, of course, I will discharge these new obligations impartially and without predetermination.
Yeah, of course.
But you know, when we look across the economy and see what is causing a lot of people harm, but maybe not a harm to the threshold of complaint investigation, you know, we get a lot of queries about residential tenancies and the intrusiveness that is a factor of the shortage in that marketplace and the sort of screening that's going on. So, you know, we might want to have a look at that, for example, and start drawing some lines in the sand. I mean, I've been reasonably assertive in the credit reporting sector because that's quite a unique business model and has quite significant risks for personal privacy. And so we'll keep a close eye on that. Access, you know, I don't know where we'll go. I don't want to preempt the Assistant Commissioner's scans or the compliance manager's advice. You know, we might see a burst of activity in the retail sector for people that are putting up CCTV stills of people they suspect of having ripped them off, or I don't know.
Okay.
We'll develop that. As to agencies, no, I haven't got a hit list or another one that I'm going hunting for on the 2nd of December.
You've obviously got, you know, you already used your powers to name in various ways, positively and constructively, let's say. How do you see this naming ability working in kind of in association with your other new enforcement powers? Will you use it more? Will you use it less?
I think I will use it more. You know, I think we do try and get alongside organisations and help them to comply. and we try and persuade, get reassurances, and get them on the right track. That's been our model for 27 years. But the public, I think, is entitled to see us taking action as well. Also, when we issue a compliance notice or something, that should be a consumer warning, right? So the reason we name is not to shame. We name to fill an objective of improving compliance or warning the consumer public. So we will continue to do that. You know, we had a conversation planning for how we use compliance notices for something, and somebody said, well, we might show someone a draft compliance notice and then they'll comply, so we won't need to serve it. And I'm like, no, we will serve it. We will go on the record because, you know, yes, it's great if they say, okay, my bad, we'll fix that. That's fantastic. But, you know, you still weren't complying. I'm still going to give you a notice, and I'm going to come back in 6 months and check.
Yeah.
And, you know, because if we don't, I'll come back in 6 months, find that they haven't done it, and I won't be able to get into the Human Rights Review Tribunal and access the penalties that Parliament thinks I should be deploying in order to promote this compliance.
Can we talk a bit about that? So obviously a lot of your new powers rely on the tribunal, and there's been some criticism in that, to enforce them, and there's been some criticism in the past that the tribunal is not resourced to meet that demand, and obviously it's been growing its resourcing, but still timing is not a wonderful quality there. And so how do you see this impacting the effectiveness of that stick, if you like?
Well, I don't know. We'll need to talk to the tribunal. I mean, it may be that they will put different tracks, because you know, the cases that they're hearing at the moment are de novo, and they are you know, formally pleaded with statements of claim, statements of defence. Witnesses are briefed. They have, you know, 3 or 4 day hearings. They've got to convene a panel. I'm not sure that the same approach will be needed, but I haven't had this conversation with them. But you know, I think there may be a faster track for dealing with these kind of notices, access determinations, and compliance notices.
Okay. And on that kind of, let's talk a bit more about enforcement. One of the new things, of course, is that you've got the express ability to enforce the Act against agencies overseas that are carrying on business here. Facebook obviously is a prominent example of that. How are you feeling about that? Is that something you'll put some focus on? Is, well, how do I look to enforcing overseas? I guess one thought is that it might be, you know, the questions of how heavily do you come down on this initially to show that you're going to use this extraterritorial jurisdiction?
Well, we've always had the belief that an organisation like Facebook that is so obviously doing business in New Zealand is subject to the New Zealand Privacy Act. So this simply puts that beyond doubt. The reality of enforcing, you know, against an organisation that earns more in the time we've been talking than I get in a budget for a year is, you know, the practicality of it. You've got to pick your fight. And the experience that the Commerce Commission had with Viagogo last year is a really sobering example of that. You know, they brought proceedings under the Fair Trading Act, which has the explicit extraterritorial effect against Viagogo, which is a Swiss-based seller of dubious tickets and so on. But they have no physical or legal or employment presence in this jurisdiction, and simply ignored the Commerce Commission for the entire investigation, ignored it for the entire proceedings until the first day, in which counsel appeared, and there's some sort of legal fiction about the capacity in which they appeared. They kind of, I'm here but I'm not really here capacity, and said, you have no jurisdiction to make interim orders. And so again, you know, we've got a very clear statute, but it took proceedings in the Court of Appeal before that company acceded to the jurisdiction and altered its practices in accordance with the Commerce Commission's investigation. So that is a really significant investment of resources, and not to be undertaken lightly. And I'm not, you know, afraid of looking at the practices of an international digital business and criticising them or calling them out or serving a notice.
Yeah.
And we will continue to do that where necessary. But whether I want to spend 5 years and half my budget litigating against someone for a point of principle, I have to ask, is that in the best interests of the New Zealanders who are not able to directly assist with complaints or some other mechanism to do that?
Well, I mean, you've effectively showed your ability to name overseas agencies, and I think a lot of us enjoy that about the way you work, is this outspoken nature of not being afraid to challenge these kind of corporations that are bigger than countries and put your position on the line. So, I mean, there are probably various tools that are available to you in that sense as well. But I'm excited to see how that works over the years, and I don't doubt that you'll get out there and sink your teeth into a few of these global platforms, and it's going to be quite fun. And now, before we move to open to the floor for questions and run through a few more of these Slido questions, I just thought I'd give you the opportunity to tell us about any other tools or plans you've got in terms of making privacy easy for agencies under the new law. I think there might be a tool being developed around the cross-border.
Well, we've got Notify Us, which we have invested in to both help agencies understand whether they've met the threshold for reporting a privacy breach. Our instruction to developers for that was to say, assume people who are using this know nothing about their legal obligations. What they know about is the thing that's happened. So they put that into our questionnaire, and our algorithm will tell them, well, we don't think you're there, or yeah, it looks like this could be one that you should notify. And when you reach that point, you can press a button to continue, and we'll import that the data that you've input already, and you'll get the rest of the information you need to report, or you can dump it and walk away and leave no trace. So that's going to be useful, I think. We have the model contractual clauses. They're ready to go, and we've just briefed a developer to convert the legal contract that Chapman Tripp has given us, plus the guidance, into a kind of Privamatic style contract builder. So you'll be able to input 2 or 3 data points and produce a printed off or electronic version to accompany the information that you're sending overseas. We've got all our online e-learning training. So we do that in conjunction with LearningWorks. We've got a new module called Privacy 2020, which just updates all those changes. But all the old modules are being updated as well. So those will, Privacy and Employment, Health 101, Privacy 101, Privacy Impact Assessment, all of those remain on our site. There's a blog post. Most of the people here in this room, I imagine, are privacy geeks who are familiar with the 1993 Act. You might pick up the 2020 Act and go, oh, where the heck is that section that I used to love and read 2 or 3 times a day? Well, if you look at our blog posts, a few weeks ago, our team here produced a table allowing you to track from 93 to 2020 and back. So that's, what is that called, Braden, that blog post, do you know?
Comparing the Privacy Acts.
Comparing the Privacy Acts. So, print off that PDF and have it beside your desk, so you won't have to panic about where that beloved section has gone.
Okay, awesome. So you haven't done much then. There's not much coming. No, it sounds great. I mean,
and podcasts and videos, and there's plenty of stuff.
Okay. All right. So moving on to some questions, and this first one I just want to ask because we are live streaming, and I'm desperate to get you into some kind of diplomatic faux pas online. What do you reckon about Australia's privacy laws? A question here about how do they compare to New Zealand. I mean, let's face it, most overseas disclosures from New Zealand are likely to go to Australia. So what's your thought across the ditch?
Well, again, I have to not be diplomatic, but judicious in that the system for whitelisting countries is that the Minister of Justice will issue a regulation specifying countries on the advice of the Privacy Commissioner. So I'll undertake that assessment and provide that advice at the time. Of course, the significant difference between New Zealand and Australian privacy laws is the small business carve-out in Australia. So the Australian Privacy Act doesn't apply outside the health sector and I think the credit sector to businesses with a turnover of less than $3 million. Is that the threshold?
3 million,
yeah. So, you might say it's comparable if it's going to an agency that's covered by the Privacy Act, but then you may need to take extra steps if it's a smaller organisation
Yeah.
outside those covered industries.
Okay, so I mean, the clear thing is this is not going to be an easy thing to deal with, which is why model contract clauses are so very helpful, by and large.
Yeah, and I think, there's still, at its core, a risk-based approach that industry will be taking to this. They might say, well, this is a colleague organisation that we trust, so we're happy that the information is not going, we're going to take risk mitigation measures to ensure that the information is going to be safe, and they can live or die by that decision.
Yeah, okay. So in the last 10 minutes, open to the floor for questions, and I think we've got a mic and hand shot up right here, so first one.
Like, John, employers have all sorts of personal information about employees. It might be curriculum vitae, reference checks, documents of disciplinary proceedings, performance review, wage and time records, medical records, etc. Do you have any advice to employers of things that perhaps they should be more mindful of or diligent around come December? And also perhaps the second limb of that question, when the parties are negotiating employment agreements, do you think that there should be expectations covered off in employment agreements to a greater extent than what tends to happen now?
Well, to answer your question in the context of the Privacy Act 2020, I can't think of any change, except for one in relation to evaluative material, but I can't think of any change from the 93 Act to the 2020 Act that affects that question. So whatever employers are doing on the 2nd of December, they're in no greater peril than they were already. They should be minimising what they're collecting. They should be getting rid of it when they don't need it. They should be keeping it safe when they've got it. They should be being very clear with employees how they're going to use it and where it's going to be stored. They should be offering employees maybe once a year to say, hey, do you want to have a look at your file? Proactively engaging that Principle 6 obligation. So those are sort of some of the steps that I would encourage employers to take. Whether there's anything that needs to go into employment contracts, nothing springs to mind, but if anybody else has got any ideas, speak up.
Any other questions?
There's one here.
You talk about employment. Sorry, can you hear me?
Yes.
Employers typically, and actually you've got an example here today, you want us to ask questions via this app. Now, no doubt that app will be scraping a bit of our personal data out back there. HR use programs, you set programs when you go in, you may use SurveyMonkey, you go out the back of all these sites. They're offshore, they're scraping the data in total at the very least, and frequently in more detail. What's the story there? Bearing in mind employees don't have a lot of power in that relationship. Even Microsoft regularly wants you to fill in your personal details to log into these systems.
I don't understand your question, sorry.
Oh, my question is, if employers disperse your personal information to third parties, and those third parties are doing it in total, scraping it, doing all sorts of things. Few of them are located in New Zealand, and chances of suing them are about zero. And you have no say that your information is dispersed.
Okay, so I can't really run through a laundry list of apps like Slack or SurveyMonkey or I don't know, whatever ones are being used, but the basic principles are that the employer should do due diligence on those. We use a lot of those tools. We always do a privacy impact assessment before deploying any third-party software. The basic rule is that of employment law, if I stray out of my lane a little, employees are obliged to follow any reasonable instruction of an employer. And if an employer has deemed that a particular technology is an important way of achieving, an efficient way of achieving their objectives, and are satisfied that the information is kept safe, then an employee can be obliged to use that. The conduct of the host platform is also subject to scrutiny, and an employer should do due diligence and inform staff about how those tools are going to be used. And if you have any concerns about them, that you should raise them with your employer. I mean, it may be that you can use a SurveyMonkey anonymously or pseudonymously. So there are a number of other ways of addressing that.
Might also be worth noting that you mentioned the idea you can't sue these big platforms, which is probably true, but remember that this is a controller-processor relationship, so the employer can make a complaint and has redress against the employee, has redress against the employer as the data controller. They still made the decision to use the platform, so there is redress there via the agency that's used those platforms. But we'll move on, because that's a very specific question. So is there another question we've got on Privacy Act 2020?
Thank you. Does that also apply then when we think of young people and children in the New Zealand context and in around learning tools in the education sector? So just interested if there's been any change, any looking into that, or have you just addressed it with that same answer?
Well, you know, I mentioned when I did my once over lightly of the background to the reforms that the Law Commission, when it reviewed the Act in 2011, said the fundamentals are working pretty well and made only fairly modest recommendations for change. But the Act has had a complete rewrite and modernisation. The Select Committee were very exercised actually about this issue of how we should regulate for collection of information from and about children and young people. They hummed and hawed. One of the difficult issues I think they grappled with was if we put hard rules like COPPA, which is the Children Online Protection Act in California, then you drive agencies to collect more age information, and you know, is that you know, lead to unintended consequences. In the end, they modified Information Privacy Principle 4, which is one of the collection ones. It says an agency that's collecting personal information shall not collect it by means that are unlawful or unfair, or that intrude to an unreasonable extent upon the personal affairs of the individual concerned. And they've added in the words, especially taking into account whether it's a child or young person. So that means when we think about the fairness of a collection, we raise the bar when the target audience is children and young people. So it would apply to those learning platforms and the like.
Any other questions?
Hi John, I'm an IT manager. I look after a lot of digital data. I often get asked to look after our sort of security and information, and I'm responsible for all information. If a briefcase going down Lambton Care has taken off one of our staff members and it's filled with other people's personal data, and that person was writing that down during meetings or meeting with people, for context I've come from a recruitment company, how do we judge if that person does not recall all the information that was stored in there in a non-digital format? We don't have any context about what was being captured during those meetings. How do we judge whether or not that may be a serious breach if we don't know the context of that particular breach?
Well, presumably the person who's holding the briefcase knows what they wrote down, right?
I would hope so.
Yes.
In a lot of cases we have issues with that.
Sure. I mean, if they are a drug and alcohol counsellor, I'd say the chances are that's pretty sensitive information and high likelihood of serious harm. If they are a paper wholesaler, I was just channeling Ricky Gervais's the office there, then probably it's not particularly sensitive. You know, if they are an intelligence officer at the Security Intelligence Service, you know, you can make assumptions, I guess, about the context and the likelihood that it's going to be have information that could cause serious harm.
We've got 2 minutes left, and I might end on a very quick question that's come up on Slido, which I think is an interesting one. Probably requires too long an answer, but anyway. This idea of carrying on business, so an agency overseas is carrying on business in New Zealand. It has relevance in two places, I guess. One is you exerting your jurisdiction overseas. The other is in agencies assessing Principle 12 compliance. How easy do you think that assessment of carrying on business in New Zealand is going to be? And you know, we've seen it around things like GDPR, people thinking that because they have a website that someone in Europe can access, therefore they're covered by it. And we see these kind of ridiculous interpretations that go too far. Do you think this is going to be a problem for us here, or do you think it will rarely come up?
I don't think so. I think it'll be pretty obvious.
Yeah.
And the consequences are not onerous. I mean, if you decide that you are carrying on business in Europe and are therefore subject to the GDPR, you know, you've bought yourself a world of compliance costs, right? You've got to have a representative in Europe. You've got to do a whole lot of things. Whereas if you're subject to the Privacy Act in New Zealand, sure, you need to have a privacy officer, but you don't have to register that person. You know, it's a pretty low level of cost. But no, I mean, we will see. You know, there are legal tests. You know, you can look at the Viagogo case. You can look at my counterpart in Australia has just won a case against Facebook with a very similar test of carrying on business. And she's asserted jurisdiction in relation to the Cambridge Analytica breach, and the High Court has just upheld her assertion based on the carrying on business test.
Okay, yeah, excellent. All right, well, look, we're at time. Unless someone has a burning question that they will regret not asking for the rest of their lives. Anyone? Hands? None? In that case, please join me in thanking John Edwards for giving us his time today.